Coming to you almost live from the heart of the NYPTI Radio recording studios, high atop 107 Columbia, with both eyes on Eagle Street, welcome. Today we will be adding another to the series on speedy trial time. This one is Motions and Other Proceedings Concerning the Defendant, Excludable Time Pursuant to 3034A. To begin with, let's set a basic rule that you must remember when dealing with the subdivision for excludable time periods. All excludable time pursuant to subdivision 4 of 3030 do not require a previous or present statement of readiness. As the statute instructs, the people are not required to be ready when any of these subdivision situations exist. Now, while there are some exceptions to the general rule that this time is all excludable, overall, these bases for excluding time are not a function of past or present readiness. Thus, in a felony case, these subdivisions apply prior to the time the case has been indicted, as well as the time after the indictment has been handed up, but before the defendant is arraigned. Pursuant to subdivision 4A, time is excludable when either the people or the defense files a motion, not just when the defense files a motion. The time it takes for the other party to respond, as well as the time it takes for the court to render its decision, is also excludable. If the motion is one for which the answer impacts how the people will next proceed, such as a motion to suppress, the people are given a reasonable time in which to prepare for either the hearing or the trial after the court's decision. If a hearing is not ordered and the issue is decided on the papers, there is a reasonable time still given to the people after the decision has been handed down to the parties by the court. Also, demand letters for discovery and bills of particular are not chargeable to the people and are excludable under this subdivision. Demand letters for discovery and requests for bills of particulars and the time it takes to respond to them are also excludable under this subdivision. Motions made by co-defendants are excludable time due to subdivision D, which attributes all excludable time resulting from the conduct of a defendant to all his or her co-defendants with whom they are joined for trial. Now, it does not attribute to the co-defendant if they are not actually joined for trial and their cases have been severed. An important exception to this rule excluding motion time is when the defense moves for dismissal of the indictment and requests the court to inspect the minutes of the presentation of the evidence and the charge given to the grand jury by the district attorney. If the people do not supply the court with those grand jury minutes from the presentation in a timely fashion, the speedy trial clock will begin to run against the people, even though the motion is still pending, or even if the people have answered ready for trial. Because the people control the grand jury minutes, the trial cannot proceed without the determination of the accusatory instrument is proper, and this motion cannot be decided without those minutes. Here are a few examples of other areas of excludability under this subdivision which you might overlook. When the defense serves a notice of a psychiatric defense, the time that is required for the defendant to be examined by the people's doctor is excludable under this subdivision. When a defendant is on trial or engaged in any other court proceeding on another matter or another case, the time will be excludable under this subdivision. The Court of Appeals, in the case of People v. Brown from 2003, held that this subdivision covers an adjournment where the defense announced its intentions to file motions on another case of the defendant. Even though the defense never filed those pretrial motions, the time was still ruled to be excludable. DNA testing requested by the defense is excludable. This means the time it takes to do the test and to do any matching that is requested. If the court improperly dismisses a case, the motion time needed for the people to restore the case is excludable, and the people are not required to be ready on the date that it is restored. The people are given a reasonable time in which to prepare for trial after a successful appeal. We have identified a number of areas where time can be excludable pursuant to this subdivision. For the authority for these positions, please see the written version of this NYPTI practice tip, Motions and Other Proceedings Concerning the Defendant. As always, our thanks to our crack producer, Jonathan Marconi Crespino. Be well, my friends, and stay ready.
Does anybody really know what time it is?